That's child porn. We got it. All right. All right. So we've got Matt Grant. Matt, you've got your audio is blocked. We can see you, but you're muted. Can you unmute yourself?
Yeah, sorry, I was waiting for you,
All
gentlemen.
right, there you go. All right, so we've got Matt Grant on. Matt, you are an attorney. You've been practicing for decades, I think. Though you are taking a break from like the legal work you get paid from to take on a cause because you're a litigant in family court, I guess you'd call it, in St. Louis County. And before we get into your story, I got to play something because whenever we talk about the topic we're going to talk about, we really got to play this. That is Sarah Plebin from a 2021 Zoom conference. She was leading the Zoom conference. She's one of many corrupt guardian ad litems, one of the most corrupt, not your guardian ad litem. However, let's listen to her.
And other than that, we're going to, the meeting is this afternoon that Judge Burton is calling. And I think now that more judges are being called out and named, I'm sure it has gotten their attention, but this threatens to take down the entire system. The judges are in on it.
This threatens to take down the entire system. Hopefully, the RICO lawsuit that you filed will take down the entire system. Is that what you're hoping? You filed a civil RICO lawsuit. So RICO, Racketeer Influenced and Corrupt Organizations Act. So before, I want to do it in like three parts, the interview with you. So first of all, in the RICO lawsuit, you allege systemic abuse and corruption. But what does your lawsuit allege in the larger whole against the St. Louis family court system?
Yeah, so thanks for having me on. And bear with me, this is my first time being interviewed or doing a podcast. So I'll muddle through, as a partner of mine used to say. But so yeah, what I've been able to confirm is that my experience is not unique. So I have, and if you look at my complaint, I've listed by somewhat anonymously by witness 1, witness 2, witness 3. But I've gone out and interviewed and have a number of witnesses lined up, ready to testify in my case.
And we're looking at the lawsuit. It's 170 pages. We're not going to get through the whole thing.
Right.
Yeah. So, but you've interviewed a lot of other litigants, we'll call them, a lot of other victims. But when you say that, what is the pattern? What did you and other people find about St. Louis County? And that's the area that actually surrounds the city of St. Louis, which is its own county. It gets a little confusing, but I learned that from covering this. But what is the pattern that you found?
Yeah, so here's what I know to be true, and I'm going to prove, is within the family court, and this doesn't include every family court practitioner, right? But within that bigger circle, with that huge circle, there's a smaller circle. And within that circle they're all lawyers, and they fall into two buckets. They're practicing lawyers, and they're practicing lawyers that serve as guardians ad litem. And they represent
you. In that basket, there's about 40 people in that Zoom conference. It's called St. Louis Family Court Corruption. Everyone who was on that Zoom conference, including your lawyer, Matt Eilers, who was on that Zoom conference, is a part of this basket you're referring to.
That's correct. I believe that call was all guardian ad litems, that Zoom call, and I believe that if you listen to that, there is that video is very telling. And it fits in part and parcel with exactly what my allegations are, which is this has been going on for years. There's a group of judges. I can't make a broad brush allegation. I only know of the judges in which the judge that I've appeared before, the circuit judge, Bruce Hilton, who's also the presiding judge of the 21st Circuit. And Commissioner,
let me interrupt you. One thing that you point out in the lawsuit is he replaced another corrupt judge named Michael Burton, who retired as a result of the investigation that my former friend Megan Fox and I did, because he was caught in an email to the corrupt guardian ad litem, basically bad mouthing a lawsuit and saying, I've told the other judges, and essentially completely tainting this lawsuit by Avita Tolu. And so he had to retire. So Hilton replaced Burton. Is that right?
That's right. I'm sure that to the extent he has a chance to testify, he would dispute that is how his retirement came to be. But that is exactly what I think the fact
is. But that's at least correlation. I can tell you.
No,
right.
I believe, like I said, it's systemic. It's been going on for years, which is why RICO applies.
Right. And your guardian ad litem, what's his first name?
John Fenley.
Is a guy I'm not familiar with. I don't believe he was on that Zoom conference. Hilton, I'm very familiar with. He was in the Vandenberg case, one of the more notorious cases where the girl disclosed a billion times. It wasn't a billion, but it was a lot. She would disclose to anyone who would listen, and they forced her mother, Caroline, to split 50-50 with the child molester, Melia or whatever his first, I think she calls him Mel. And Hilton was the judge who presided on that, and Elaine Podlowski, the most notorious guardian ad litem, on her way out, he sang her praises for reasons that aren't clear. But that's where I know him from. Yours is the second or third, like, really controversial case that I've heard him on. But so continue with what you found in St. Louis County.
Yeah, so as I mentioned, within the broader group, there's a subset of at least, and to back up, Commissioner Greaves recused, but she under false pretenses, which why she really recused is I caught her in ex parte judicial communication, which I explained in my complaint. By the way, the complaint's in two parts. The first 47 or so pages is a master summary. I wouldn't expect many people to read beyond that, and that itself is a big chunk to bite off. But I tried to organize it so that very few people would need to read the entire thing. But in that summary, I lay out exactly what happened is Judge or Commissioner Greaves entered a sua sponte on her own order, helping the other side on specific items that they needed to fix without even being asked. So she obviously she was there was ex parte.
What you're saying is she was acting as their lawyer.
Well, she was fixing, she allowed them, here's what she did. She reopened discovery for them to serve discovery that they overlooked, which they served a couple hours later on the same day, even though no one knew this order was coming. And they allowed both parties, although I didn't need to amend their complaint, their motions to modify, and theirs was fatally defective. And they didn't know it until, well, that's a long story as how they figured it out. I will note, Elaine Podlowski was my mediator. So that is an interesting tidbit for you. So anyway, and once I outed, if you will, I outed Commissioner Greaves, I put in a lawsuit. I'm sorry, I put in in that filing and a motion for sanctions thereafter that I was going to do what I've done, as I'm going to sue these people because it's wrong. I knew something was wrong, and then I finally figured it out, and I had no idea how pervasive it was, but I figured it out with Commissioner Greaves and my kid's mother's lawyer, Maya Brody, who's on the ethics commission for the state of Missouri, which I hope we can talk about. Right. But anyway, I put in a pleading that, hey, you're not immune from all causes of action. I'm going to sue you people for what you've done because you need to be held accountable.
And I think you argue in the lawsuit, OCDC, that's what you're referring to. I can't remember what the acronym stands for, but that they strategically place members of this group in strategic positions in OCDC to make sure that no complaints against anyone in the group ever go anywhere with the bar. And I can't remember the woman's name. She's now married, or she was married to Evander Holyfield after we did the video. But there's a notorious part of the video where they're like, listen to her. She's on the OCDC committee. And it was a black woman. I can't remember her name, but she was on OCDC. But I think that's the allegation you make, that basically OCDC has been corrupted to protect these lawyers.
Well,
right?
So the allegation, to be clear, what I think the evidence will show, and let me back up. This is all about what I believe the evidence will show. Big picture, this is what this case, if you read my complaint, it's so lengthy because I don't want anyone just to take my word for anything, right? So what I've done is a lot of people don't do is I put the evidence in the complaint, just so because this may sound far-fetched to some people, but this is actually true. And hopefully we'll get to some of my background, but I have the credibility here that I think, well, that I know I will be taken seriously on these allegations in the federal court where I typically practice. And then, but anyway, back to what I was talking about is, the OCDC, there's been a number of irregularities. I've reached out to them by phone on December the 31st to confirm that I was going to be reporting one of their, not only, a member, but a special representative for St. Louis named Maya Brody. And I said, this creates an internal conflict of interest. You need to make sure that obviously this is handled separately. And I asked how they do that. They would not disclose the details, but they said they would make sure basically it was walled off and treated, I guess as best they can. Internally. Just
very quickly, you cited some of my work. You cited some of the work Megan Fox did when she was at PJ Media. I think she still is there. So our work is like it's not critical, but it's the backdrop to everything you learn. We springboarded what you did here and helped put the pieces together, what Megan and I did in 2021. I think that's a fair characterization.
Absolutely. Well, and thanks. And I have a Facebook, my personal Facebook page. I've made some comments, and I think I put it in my complaint as well. Is you know, I'm just the latest victim. I'm not the first, and there's so many before me that have tried to do what I'm trying to do that I wanted to recognize their efforts because without their efforts, we wouldn't know what doesn't work.
Right.
Which and because this is going to be a difficult battle legally, and so yeah, no, others have tried this,
Right.
and I think
And
I will.
you mentioned this email several times.
Right.
So I want to talk about this email. This is it's not. I'm not revealing anything that's not already public. This is from the Vandenberg case because I released this email first in 2021. But it is important that we get so whoever it was get evaluated since we are buying future litigation. Now you mentioned this several times. Why do you think this is such an important email?
Well, I mean, this shows the what the corrupt pattern is. So under RICO, there has to be a pattern in practice, and this is what it is, right? So they take active measures to perpetuate litigation. Like my case has been going since March of 2024,
Mhm.
and it's yeah, I mean, it's just insane. And this is what they do in every case, and they try to take collude to take particular steps and actions to perpetuate not only the case that's existing, but also it appears in that case at least that potentially future cases or future disputes in the same case. But that's what this is all about. Is it's a financial scam. It's a criminal. It's a RICO like any other criminal.
May I interject? I think the
Please.
we in that email also coalesces the enterprise nature. You don't talk
Right.
about yourself as a we unless you view yourself that your intent and your modus operandi and your course of dealing is one of more than one and several. And what is that we? Yeah, that's
Right.
a question for the people. What do you refer to when you talk about we? And we talked
I
about RICO
also
before.
I also think
like
that
to hear.
I also think what Sarah Pleben said, this threatens to take down the entire system. And this that she was referring to was a lawsuit, not exactly like yours, filed by Avita Tolu against Elaine Podlowski. And for reasons that aren't entirely clear, almost 40 people got together to talk about this lawsuit. And also there was an emailed newsletter at the same time going after Elaine and others. But if one person gets sued, other people will say that's tough, that sucks. But usually they don't get together on a Zoom conference unless a lawsuit threatens the entire system. So I think both of that does suggest that there's a pattern, but I think you have to have more. Am I right to get this to pass a motion and dismiss than just simply an email that suggests that there's a pattern of buying litigation? Am I wrong?
Well, no, I agree with you, and I have more than just the email.
Right.
So what I anticipate is certainly a motion to dismiss. There's two particular rules that I'm familiar with that they'll probably rely upon, but this should survive.
Okay.
So under the RICO, so I have multiple. There's 13 causes of action,
Right.
but and I know we may want to talk about some legal issues. I don't know how much you want to get into it, but we've got immunity issues, all these other things.
Right.
But I've sufficiently alleged and there's federal rule called 9B, basically applies to fraud. You have to use factual specificity when you bring in a RICO cause of action. That's why it's so lengthy. There's so many references to months, dates, and times. Is that I've alleged, and this is what the court will have to do when it's presented with the motion, which is take all of this as true. So assuming all of this is true.
I wanted to get into that after. Let's talk about your case, just to lay out your case without the legality of the lawsuit. So if I understand your lawsuit correctly, for years and years and years, you and your wife split the kids 50-50. No one ever said you were a bad dad. And I think you didn't accuse your ex-wife of being a poor mom either. And then you wanted to, very quickly, you've been a lawyer for a while. You've been a litigator, which means you argue in court. You filed both locally, federally. I think you've worked for big law. You're a law partner. No one can question your legal credentials. You're in the top 1 or 2% of all lawyers, and it's certainly in Missouri. So that's your legal background. But you told me you're taking a sabbatical, if you will, from the legal work to do legal work on this. So right now, you being a lawyer is strictly focused on this lawsuit and anything that comes out of it.
Yeah, and this is I'm sorry. The cost of this to me is substantial. I haven't, actively practiced since late January when this really blew up. because, and I won't go into the whole thing with the current firm I'm with, but in any event, I decided voluntarily to step back and focus just on this. And that is my current situation is this is what I'm doing full time.
Okay.
Is this my litigation, which is still ongoing. My case is still ongoing. And then this
Right,
federal
and
litigation.
they're keeping you away from your kids, and they've cut the already very small amount of time you had. You say in retaliation, but you say you're an alcoholic, and I think it was March of 2024. You relapsed. You immediately, you said in the lawsuit, voluntarily gave up custody temporarily, and then went into rehab. You went into rehab. You got out of rehab, and I think right around there is where you hired this guy Eilertz. And Eilertz took your money. I'm assuming you paid him. I doubt he took it pro bono. And from the lawsuit, did nothing, it looks like, and definitely did not fulfill his fiduciary duty. And I don't think you're suing him for RICO. I think it's malpractice. And that
Correct.
to me was very strong. I reached out to Mr. Eilertz, and by the way, he was on the Zoom conference. I looked. I when I read the name, I was like, that sounds familiar. Megan, Evita, and I talked about him. He was Evita's lawyer. She said he took 160,000 and then shows up at that Zoom conference which is against her. So that's Eilertz. But you, after you get out of rehab, you take a bunch of drug tests and alcohol tests. They pass every time. And at some point, your ex-wife sends an email, I don't know who, but to someone basically saying, oh man, my child support is going to get cut. I don't know how I'm going to make it. And then it's suggested to her, well, just go for sole custody then.
Yeah.
And so what happens next?
That's really, so yeah, so let me take those in turn just briefly. So yeah, so I did hire Mr. Eilertz actually before all of this, which will come into play if you read the allegations, before this lawsuit was even filed, because this was not a surprise and I was working through it. And I knew I was going to rehab and I was in that process. And, but anyway, me and my wife and I and my therapist, we were trying to find a place and the right place. And that's a process. It just really is. And I don't know if it came up already, but I'd been to rehab in 2019. So I'm a recovering alcoholic, a recovered alcoholic. I think it's recovering, but whatever the terminology you want to use. But in any event, so yeah, so I was on my way to rehab regardless. And then unfortunately, this case went down this path. But before I even returned, I had ordered, a breathalyzer that has facial recognition. So that was waiting for me on my front porch when I returned from rehab. And I started that the second I could get it. You have to pay the credit card to get it enrolled. But I've been using that machine. I was going to have it here, but it's in my kitchen. But I blow in that a minimum of 3 times a day, every day since I think it was April 20. I got back on, I think it was April 24th, which was a week before the hearing on the first hearing on April the 29th. So I've been blowing that thing past every single time I think it's over 1,500 now. Since
was there an agreement that once you prove that you're sober, that it goes back to 50-50, or what was your understanding?
Well, that is what I lay out in the complaint they move the goalposts here. This is what they do. And this is the collusion. We reached an agreement in June of 24 that said, hey, you're right now, we're going to go to, you come back here, you can have supervised visits, which I thought was outrageous, right? I come back, went to rehab. I have there's no allegations of physical abuse or anything in this case, right? I have an alcohol problem and I certainly relapsed. There's no doubt about it. I own it. Yeah. And that's what happened. But I returned and I thought, okay, this should be a short order. Let's just get this done. And then it turned into this, year and a half fiasco. But we had struck a deal in June that Mr. Fenley, the GAL at the time, I did not know that, he was involved in this corruption. I was never married to her, but my kids, my only 2 kids, her mother, and her lawyer, Maya Brody, the one who's on the Ethics Commission, OCDC, Office of Chief Disciplinary Counsel. We had struck a deal that said, hey, if you go do these things, go get a hair test. And some other things, you can go to unsupervised visitation. Well, I did that, passed the hair follicle test, 100%. There's 3 in the evidence. I've passed 100% on the hair follicle test, passed all the breathalyzer tests. There's just nothing here. And then they said, oh, that deal doesn't exist. We don't know what you're talking about. So then,
Was the deal in writing?
No, and that's one of that is reference to my allegation against my former counsel. Is that, I'm not I'm a lawyer. I'm not a family lawyer. You know, in hindsight, you can look back and say, you know, maybe I don't know. I
they're
relied
gonna
upon,
argue
hired
there
a
was
lawyer for
separate.
this area to handle this. So I
Mhm.
didn't know, you know, that's what I believe. And yes, that should have been documented and signed that day, or at least, you know, documented with the court when they were at court the next day
And
or
that's
2 days later.
part of the malpractice that he didn't
Correct.
make sure to put it in writing. So then what? And Brody was involved in Joel Fritz's case, Joel's ex-wife, I believe, where Joel's lawyer advised him to look inside his ex-wife's email, and then he sued her. Joel died under mysterious circumstances. They claim it's suicide. I don't believe that for 1 second. Joel was gainfully employed. He got his custody back. He was happy every time I talked to him, every time everyone talked to him. I don't know what happened in Joel's case, but I don't believe it was suicide. But he had what at the time was a landmark lawsuit when he died. But Brody was the lawyer on the other side in that case. That's how I know her. So what happens next?
Yeah, just briefly, or maybe we can come back to that. A little bit of inside baseball that everyone needs to understand is Maya Brody's not only on the ethics commission, her husband is on the judicial nominating committee that nominated Judge Hilton.
Right.
And Commissioner Greaves.
Right.
So, I mean, this is all incestual. I hate to use that term, but I don't know a better
Right.
term is, you know, it's all incestual, how everyone is related to each other in the, you know, I would argue
And
that, yeah, the favors that are owed here.
right. Let me interrupt you. In most of Missouri, it's a straight election. That's how you become a judge. But in St. Louis County, a panel that Brody's husband is on takes applications. That panel cuts it down to 3, and then that panel sends those 3 to the governor, and the governor chooses from those 3. One of the worst ways of getting judges, and the process needs to change. You need to get rid of that. And Idaho has something like goofy similar where the bar chooses magistrates. So that panel you're referring to is the panel that takes these applications and then chooses 3. So obviously Hilton owes Brody's husband. Brody is on Hilton's case, and Brody gets favorable treatment, and you don't think that's a coincidence?
Well, no, and maybe it's not that there's anything owed, rather that there's an understanding. Bruce Hilton, Judge Hilton, was a family court practitioner before he was appointed to be a judge. He was part of the system before they put him on the bench to continue the system from being a lawyer to then being a judge. And that's how this is how it perpetuates. And what you reference is the Missouri Nonpartisan Plan, which is somewhat complicated and a little bit broader. But yeah, I do believe the Missouri Partisan Plan, I think I put this in writing, is not, it's far from nonpartisan. It's, you know, it needs to be scrapped.
Direct elections are the best. They're still flawed, but it's better than the way this is described. But so how give some examples of how they like perpetuated your case and dragged it out, rather than having a conclusion.
Well, so first of all, you know, when I got back from rehab, there was a TRO that was continued by consent, which again, I don't know why that was done. But then on the 29th, there was an order entered by consent. And this is interesting. Judge Hilton, and this goes into how I knew that he was corrupt. He later called out Mr. Eilerts for this. But he said, you know, why didn't you move to dissolve that TRO once he came back? There was no longer a risk of irreparable harm. There's no need for any injunctive relief as long as this guy is proven that he's sober. And that's exactly right. Is that, and of course, Judge Hilton later changes his story and denies he said all of that. And of course, it's missing from the transcript. And that admittedly sounds crazy, but I guarantee you it happened. And I'm going to prove all of this. And I think my complaint includes an example where I found them manipulating a deposition transcript. But in any event, so that is, you know, so this all should have gone away when I got back. It should have been a reasonable request. Said, okay, you're an alcoholic. You went to rehab. We have a concern that maybe you'll relapse again. Here's a fair request, which I volunteered. You know, I was already started the breathalyzer on my own. What's a reasonable amount of time I keep doing this? And you can have your kids back 50-50 as you had for their entire lives, as long as you stay sober. That's how this should have gone. And it's not how it went. So you had consent order after consent order. I had a hearing in August. There was a preliminary injunction hearing.
But consent order means you agreed to it.
I relied upon my counsel, Mr. Eilerts, to I followed his advice on all of these things. And that is correct, is that the consent orders are signed by me on the advice of counsel, and that's why I did not hesitate filing the malpractice claim.
Mike, can I ask a couple questions?
Sure.
So, Matt, I'm going to take the devil's advocate stance here. And can you convince me now why this case should go through? So I'm sitting here from a 10,000-foot level, and I'm someone with a bit of a legal background, but even if I didn't have one, doesn't this look to me, tell me why it's not sour grapes by someone who was a family court litigant who lost? How come you're running into federal court with a case when it looks like there's a big part of sour grapes, and maybe you do have legitimate sour grapes against the attorney who committed malpractice? How does that break the threshold and translate into a federal court case? And I want you to specifically address two things that we hear about all the time about family court cases that try to end up in federal court, and that's the Rooker-Feldman doctrine and the Younger abstention doctrine. How come, even if, and let's say everything you're saying is right, you have the worst malpractice perpetrated upon you, why does this end up in federal court?
Right. So setting that aside, that is kind of a side issue. Really, that the focus of the case is the RICO Civil Rights Act case. So, and we can, I really don't want to get into the abstention doctrines, but I can explain to you why those don't apply generally, which is, I mean, and this is important, right? So I reported all of these individuals to the Office of Chief Disciplinary Counsel in Missouri that has authority over all these lawyers and over Commissioner Greaves, who recused from my case. They have never interviewed me. Their position is flawed. One, they say they can't interview me on the parties in my existing case till it's over because it might influence the outcome. Okay, that you can, I guess I can understand. But anyway, why? I asked them repeatedly, why are you interviewing me about Commissioner Greaves? She's no longer on the case. She's on the bench. That infuriates me. She's out there doing this to other people, I assure you. I mean, I don't have the proof, but I think the evidence will show that this is ongoing. And, you know, so they should have interviewed me and investigated her. They didn't. And then really the policy that I challenged, and this is also another reason the federal court needs to get involved, is the state ethics committee has decided that the most egregious of allegations against judges, the worst of them all, that they will not investigate those unless they're charged with a crime. It's exactly backwards, but that is their policy. Okay,
now I'm going to ask you, have you heard of, Mike, real quick, have you heard of Jacob Belinsky, Rabbi Jacob Belinsky in Colorado? You know what we're talking about? He just won in the 10th Circuit Federal Court of Appeals on that specific issue, that the people who are the watchers, who are supposed to be the watchers, can't act. You make a complaint to the state authorities, and you're going to get into a dead end. So I would tell you to take a look at Rabbi Belinsky's recent win in the appellate court.
Yeah, we can send you a bunch of things, but one difference is Rabbi Belinsky only wants money. You want them to change policy. Isn't that how you I think you want them to remove judges. You want a civil case to substitute for the will of the people, and you want like the federal court in a civil case to make policy for the state. How does that work legally? And isn't that a slippery slope? Everybody's going to then sue and say, I don't like this policy. Federal court, tell my county to change the policy. When, it should be the county that decides whether a policy is changed.
Well, first of all, the policy has to, it's very strict, the requirements on what you must allege to meet for it to qualify, right? So, but I want to pick up on what you said is monetary damages, right? So I do allege that, but this is not what this is about. And here's where this case has legs, is the injunctive relief. The United States Supreme Court has ruled.
That's different than Rabbi Belinsky told both of us. The reason he only asked for monetary damages is because he's looked at cases being dismissed. And when you try to step further than monetary damages, they say, no, you want us to intercede in a state issue. And then that abstention doctrine comes in. Aren't you then encroaching? Isn't that going to be a problem?
Well, it's certainly going to be argued, but here's the point: is what I allege is exactly what I said. Is I've not only gone to the Office of Chief Disciplinary Counsel, I went to the Commission on Retirement Retirement Removal and Discipline. I'm getting those in the wrong order. And I went to the U.S. Attorney's Office. I hope we can talk about that. To an individual I used to work with. He was actually he was an associate that worked on my cases underneath me when I was a partner. And so I went to an individual I knew. I've gone to everyone and no one will act. And I believe the evidence will show why.
When you say everyone, that includes the media. You didn't mention who it was. You don't have to mention who it was, but you said you sat down with a media person for hours and told your story where it's not out there. What happened to the story?
So it was an hour phone call followed by I paid to rent a room for 3 hours off site because there anyway. Sat down with this, and I hand selected this individual because of his or her background, which was in this this thing, exposing corruption. And that interview went amazing. And he was this, well, I guess I just said he, so it was a male. So this gentleman for this unknown publication, which will come out eventually. I think I can say who it is, but I'm just trying to err on the side of keeping everybody anonymous for now. But in any event, he was blown away that I would put my name on it because he knew about it. And he's like, no one's willing to put their name on this. I said, you can not only put my name on it, you can take my picture and put it on the front page of your publication or the front homepage of your publication. And he's like, this is amazing, so on and so forth. And I said, in fact, I'm going to draft a motion for, the cases, we should talk about this, but family court is sealed, or is the doors, the courtrooms are closed to the public. And that's the problem, is reporters at a minimum should be allowed in there.
You weren't married, right?
Correct.
So right, that's what's sealed. And they do a trick. I think it's St. Louis, it might be all of Missouri. If you are married, most everything is open. Because you weren't married, it's called a paternity case. It's all sealed. I did that with Angela Freiner. Her and her ex-boyfriend weren't married, and you couldn't get any information. And the judge got very upset when I would get information. But they find the difference between whether you were married and not married, whether you open it or not, seems pretty random. I wanted to ask you one other specific thing, and then let's get into like the details of how you believe legally you're on the right footing. So you're suing two judges. Graves is a commissioner, but that's a junior judge, and then Bruce Hilton. And as you know, I'm sure you know, judges are protected by this law, or this case right here. In my opinion, one of the worst U.S. Supreme Court decisions, Stump versus Sparkman. So you know their immunity is really broad. This is another case, but I think it has some relevance here. So failing to respond to arguments in support of a motion to dismiss constitutes a waiver, and this court could accept Boyd and Goldfarb, who are the judges in that case, contention, supported by pertinent legal authority, that plaintiff's amended complaint does not state a valid claim against them. Plaintiff's failure to respond decided it is clear that judicial immunity bars Kenton's claims as against the two judges. Indeed, even if it were true that they accepted bribes, and that's the allegation he made, that they accepted bribes from the Bierman defendants, who can still be defendants, in exchange for entering orders favorable to their clients, which the judges strenuously deny, the judge could not be held liable for Kenton's alleged injuries flowing from this order. To sum up, and in layman's terms, this case is so broad that at this stage of the case, you can accept that they did take bribes, because Kenton was very specific about the allegations. They deny it, but even favorable to him, what the judge is saying is, even if I accept that, I'm dismissing it because your injury comes from the orders. And correct me if I'm wrong, your specific allegations amount to orders, do they not? So wouldn't the same thing apply here? Wouldn't you have some trouble that they would say, even if everything you're saying is true, you're still alleging that these orders were corrupted and the orders themselves are protected by Stump v. Sparkman? Am I wrong?
So, and I don't want to telegraph my response to the anticipated motion, but let me give you a little flavor. Stump versus Sparkman, the U.S. Supreme Court's ruling, is extremely broad, but it doesn't cover everything. And there are exceptions. And that's what I think will come up and will be addressed in my case. But setting that aside, let's just assume that somehow that I'm currently in the District Court of St. Louis, the Eastern District of Missouri, Federal Court, United States District Court. And I think this case will go to the Eighth Circuit. But regardless, let's assume somehow I lose that argument. The point is, I have injunctive relief, and the United States Supreme Court in Pulliam v. Allen, 1984, addressed this very issue, which is, okay, listen, we're going to insulate judges with, if there's not an exception, from monetary damages, but they're still subject to injunctive relief. They're not above the law. No one's above the law.
Right, but regarding that, getting back to Kenton's, she also dismissed, now his kids are almost 18. She said, I'm dismissing it, bring it back when they're past 18, because she also said a federal case can't in a substantive way affect the state case, and you want judges removed. Aren't you going to have a problem there that you want judges removed and they're on your case? You're basically asking, the federal court doesn't want to give you a second bite at the apple. They don't want to be the place that people unhappy with a ruling in state court go to try to like fix it. That's what the U.S. Supreme Court is for. But aren't you doing that by asking for injunctive relief? I think you asked for the entire. Am I wrong? You asked for the entire court in St. Louis County to be removed, or several judges.
Here's ultimately, if we let me back up a little bit. So my complaint's drafted very specifically. So first of all, I waive any issues that the court might consider would overlap with issues that might raise on appeal in the state court. What the state court is not going to address is whether or not these acts are criminal RICO. That there will be no ruling in my case now where it is now or on appeal whether or not there's a RICO violation, so that you can carve that out. And any of the issues that the court might otherwise hang its hat on, or the other side would ask the court to hang its hat on and say, oh, well, this overlaps. I've waived that proactively to make sure that they don't use that as an excuse to bounce my case. Okay. And then what I've said is, and think of the only analogy I can think of is kind of desegregation.
Well, Matt, does that waiver bounce your case in and of itself? Can they make that argument?
No, because I can't think of an issue that it is raised in my case.
You
in
want
the federal case that will be resolved in the state court case.
Right. What you want is what a lot of litigants have said they want. You are not the first person to say that family court acts as a criminal enterprise. You're not the first person to sue under RICO, but you are definitely the most legally accomplished to do it. So let's talk about that. So RICO, I know a little bit about it. My first book about Chuck Benici, he was tried under RICO in a bogus way. So it means that there's a organized criminal enterprise. It was primarily initially used against the Mafia, but basically any criminal enterprise can fit under RICO. So you are alleging that the St. Louis family court system is the criminal enterprise?
So I defined it a little more. Well, I defined it more accurately, but yeah, there has to be a criminal enterprise under RICO, and which is separate from the individuals that are maybe members of the enterprise or maybe associates of the enterprise, and there's a bunch of legal technicalities. But yes, I'm not, like I said, I want to be clear. I can only speak to the judges that I have evidence on, or that my witnesses have evidence on.
Listen, it's a bunch of them. And Nicole Zellweger, who presided over, and the next one, Robert Heggie, they are definitely corrupt, and I would say they're part of the enterprise. There's a lot of bad judges in St. Louis County. And then you name the defendant. And there's a couple of things. Maybe you want to make sure to explain this. Some folks tried to break into your house, or they did break into your house, and then they try to get into your health insurance for something. Explain that and how that fits into the RICO scheme.
Yeah, so that is maybe, I don't know if it's the most unfortunate, but what hits maybe closest to home is two of the defendants in my case are my own sister and my own first cousin. And yeah, it's undisputed. I mean, my sister won't refuse to interview with the police when they open an investigation. But yeah, she produced photographs when they broke into my house.
Why? What were they? What was the end game to break into?
Well, and I produced in my complaint. They're gathering evidence. They're later going to argue they're somehow trying to help me, but they weren't. They were gathering evidence.
So they committed the criminal act of breaking and entering in order to get evidence illegally in your custody case. What's the deal with the health insurance?
So that is not the best. That is the most compelling story. And that's my first cousin, so me and my wife decided to tackle this on our own, and with the help of my therapist, which is, once it was clear, like, listen, it's not my first rodeo. I don't mean to make light of the subject of alcoholism, but I knew I needed to go back to rehab, right? So, I mean, it was not unclear to me. And then, so my wife was approached and said, hey, let's have an intervention for him. And she said, no, we're going to do this our own way. And at that point, they really took the gloves off. And yeah, so what they did before, well, it's in my complaint. I can't remember the exact date, but as I was, and this hasn't come up, and it's not something obviously I enjoy talking about, but I was having suicidal ideations at the same time, right when I hit rock bottom. I mean, it was the worst I've been in my life. So I relapsed. I was in bad shape. I was having the worst thoughts you can imagine. And I was trying to find a rehab, and it turns out I only found this out in June when I got the documents. My first cousin reached out and reported me and my wife for fraud to try to pull my health insurance before I could get to rehab. Now, why would you pull someone's health insurance that's suicidal and is an alcoholic and is needs to get to rehab right away? I mean, I'll let everyone draw their own conclusions, but I know exactly what they were up to.
And
unfortunately,
two questions, and then we'll get back to then you also mentioned an audio, a conversation, I think, with Fenley, or that's very significant.
It's posted on my website, which is stopmissouricorruption.com.
Okay, let's get there.
Yeah, sorry, yeah.
All right,
And,
so
it has its own page.
What's the significance of the?
So if you got the GAL top right, so June 2nd, the Guardian ad litem called me and made me a quid pro quo offer. You listen to it to yourself. Is that he offered me and said, listen, you can have your kids if you disagree that there's no criminal activity here. I mean, that's an attempted extortion by coercion. And I turned that recording into the Office of Chief Disciplinary Counsel, and I want to circle back to that. And I sent it into the U.S. Attorney's Office, who oversees the FBI. I don't know if your listeners or your audience understands how that works, but the FBI ultimately gathers evidence, but it's the U.S. Attorney, the prosecuting attorney, who decides what to pursue. So I went straight to the top, where I had a contact that I thought was going to help me.
And this is a former colleague of yours.
Absolutely, yes.
Right. So you weren't just shooting someone you knew professionally. I don't know if it's going to play. Oh, here we go.
It's 26 minutes, just so you know.
Oh, no, we don't need to listen. Okay, no, 20. So, but he now, how is explain for people who don't understand criminal law, how is it extortion to say you can get your kids back if you don't pursue criminal charges? How does that meet the elements of extortion?
Well, it would be attempted extortion, I believe, and I'm not a criminal lawyer, but it's laid out in my complaint. I'll probably get it wrong here, but I lay it out in the complaint because what we haven't talked about is there has to be a RICO predicate to pursue RICO. So that's why I go through, and I don't think anyone's ever done this in the prior complaints, is I lay out these specific RICO predicates that were violated here. And that is one of them, is that, yeah, what he's doing is exactly what you can't do, which is, he knew I had already gone to the U.S. Attorney's Office, so he's interfering with a witness in a criminal investigation. And two, he's trying to coerce me into trading, giving him a get-out-of-jail-free card for getting my kids back. And that's absolutely a crime.
But you also put the judges into the RICO conspiracy, and the predicate acts are two crimes or in civil RICO that could be torts. So violations of either criminal or civil law in furtherance of the conspiracy. And basically, what you're arguing is that breaking into your house, trying to change the health insurance, this thing was all done in furtherance of keeping the case going in a corrupt way. Do I have that right?
And I want to be clear. So the breaking into my house and the pulling my insurance was before this case was filed. So that was that's why there's 13
so
counts.
Would that be a RICO count or no?
So those are relevant to the extent of their subsequent conduct. Those two defendants joined and became associated with the RICO group once the mother of my kids hired Meyer Brody, the defendant Meyer Brody, and realized that this was their opportunity to take advantage of a cookie cutter operation that was a well-oiled machine, and said, yeah, we'll just go along for the ride. And yeah, this is great. We have a common goal. Let's take.
But you argue that, correct me if I'm wrong, every criminal act that the judges commit are orders or things they've done as a judge. How can an order you don't like amount to a criminal act?
No, it's only those. So here's the issue: is wire fraud, right? So the issue that comes up is that the predicate is, and it could be also separate from wire fraud. It could be obstruction of justice also that doesn't involve wire fraud. But what I raised on a couple of contexts, which is if the order is specifically intended to further the interests of the criminal enterprise, then it qualifies as a RICO act. So, to the extent the judge grants an extension of time or whatever, an innocuous order, that doesn't count. But to the extent his order is entered to retaliate against me, or to keep keep secrecy around what's going on around this enterprise, that is exactly what RICO is intended to do.
Give me one or two examples of orders you believe further the enterprise.
Well, no, I mean, the retaliatory orders. So this is the most compelling one, because I mentioned I had passed every breathalyzer test. Still have every single time since April of 24. I file a writ. I finally exposed this well, we should talk about the Missouri Supreme Court intervened in my case without me asking and gave me my own judge.
But Hilton refuses to relinquish the case to the judge the Missouri Supreme Court has appointed. And I wanted to ask you this: you got into it a little bit, but you believe that some Republicans in the state legislature, and you say you're a Republican, that you vote Republican almost always, but that they are going along. What is the connection between the Republican politicians and the judges?
So yeah, so this is, and I am a Republican, or at least I was until this happened. I don't mean this isn't politics for me. It's the only reason I mentioned that. I would never bring up my politics other than to say that I'm not a Democrat out there to try to tackle. I mean, you can look at I guess you can just public record where my voting rolls or my primary registration, whatever. But yeah, no, the point is that what I know and where I used to work, and I know the inside baseball, and what the evidence is going to show is what I've laid out is that I know how the system works, and I know how they use the system here to perpetuate this corruption. And I know the people that make the decisions. I know how they happen, and I know who's on the committees, who puts them there, on the commissions, who talks to the governor, how the governor makes the appointment, and then how this all perpetuates and works together. I have that knowledge that is unique to the world that I used to live in and do live in.
You didn't really put that into the complaint, though, the specifics of all of that, or did
you?
Well,
I tried not. There's a lot there again. So there's a lot of stuff that, again, I'm trying to put out there the objective facts, and it's everything that happened to me is too much to swallow at one bite, right? So I don't want to be viewed as this conspiracy theorist with the red yarn on the wall, connecting everything together. But there's so much more to this story. I think I put in there, I could have another 50 pages of allegations. But what I allege, and I think this is noteworthy, is that and I asked in my motion that the Missouri Supreme Court, it was not filed with the Missouri Supreme Court, is I wanted a Democrat judge appointed in my case. And the Supreme Court, and I asked that, I filed that in a motion in the state court. The Supreme Court on their own, which I presumably they were watching once I was turning all these folks into the OCDC. Someone, I believe a mole, I don't believe it was official, but I think a mole, but we'll see, alerted the Supreme Court. They assigned me a retired Democrat judge. I do not believe that was an accident.
Let's get back to the question I asked before we got off on this tangent. So one or two of the most compelling orders that you were going to show for evidence of perpetuating the criminal conspiracy.
So ultimately, when I didn't know that order came down from, this is so important. So the Supreme Court issues that order on March the 4th. I'm not told about it. It's not placed on the court docket, which has to happen, which is the normal course of every case. I end up getting no ruling from Judge Hilton on my motion for change of judge for weeks and weeks and weeks. So I file what's called a writ. I file an appeal, immediate appeal, in the Court of Appeals in St. Louis on March the 26th. On the 27th, he takes my kids. 100% of the time, 24 hours later, under the guise that I'm drunk and in rehab, when they know that they have access to my breathalyzer records. I mean, it's just outrageous. It's outrageous.
You've got another order that's compelling like that?
So there's so many. That was the other one is when I showed up. So they took my kids 100% of the time. And then when I showed up to appear to argue that should be, setting aside whether that order was proper or not, it clearly was improper. The order should no longer stand because I had proven that I got another hair follicle test, and I put in front of the court the breathalyzer test, which, by the way, the court, Judge Hilton testified, or he refused to admit it for what it stood for. He said he needed an expert to interpret the test results. The drug test results that he ordered that says the drug name, cocaine, it says positive or negative. It says negative. I mean, so I've called him out aggressively on that because that was short-sighted on the precedent he was setting, and he's since backpedaled from that. But that is just an example of the lengths that these people will go to try to keep me down and retaliate against me. But so when I showed up to argue that motion, on the date given to me and agreed upon by the court, I showed up and they said, oh, this is not the right sort of hearing date. You'll have to reset it. Come back in a couple of weeks. I don't know if it was 1 week or 2 weeks. But everything is about punishment and retaliation. So when they took my kids away and I finally showed up and convinced him that, hey, you shouldn't have taken my kids away because I wasn't at rehab and I wasn't using alcohol or drugs, he didn't even go back to where I was, right? I had my kids overnight once a week, had a visit every Wednesday, had a visit every other Sunday. So what he didn't even go back to status quo. Then he goes back to say, well, you can have your kids one night a week now. And then we go forward to trial. And now, because I wouldn't settle a trial, by the way, the guardian ad litem came to me and said, I think I can get you every other weekend. And I said, no. I said 50-50. And then after trial, during trial, they asked me to apologize and try to recant my story. And I thought I didn't know if they were going to be that, what's the word I'm looking for here that's appropriate and not offensive. Well, I didn't think they would actually go there because they asked me directly, and I'm not going to lie. I said, no, it's all true. And they should have never, that's the whole point. He couldn't have been my judge, and I shouldn't have been asked that question. But after trial, he went from now, the guardian ad litem that was in favor of and thought he could get me every other weekend, and was offering me in the phone call that is recording, getting my kids back. Now he's recommending that I have my kids twice a month.
And this is after
overnight, twice a month, and 2 visits on the other weeks.
Rich, I've been monopolizing. You got a few questions?
Well, listen, give me the media bite. Okay, give me the 30 to 45 second that we can explain to everybody here. You're doing a great job talking the legal predicates and everything else, but we're media, so we need to explain to people who aren't legally trained what's the big deal here and what you're attacking and why you're going to succeed. So can you do that for us, Matt?
Yeah, I mean, I don't have anything prepared, but I mean, the big picture is there's been a RICO conspiracy that's been ongoing in St. Louis County Family Court. Anyone that does a Google search knows about it. Those who live here know about it. What they did was try to victimize me, which is that was incredibly, ballsy, because they came after me. And I am the one, I have the skill set to fight and to end this. I mean, the other people that have tried, you can't, by the way, I haven't been able to hire a lawyer. No one was, it's not because they don't believe me. I mean, anybody can hire a lawyer. Lawyers take money. No one wants to touch this thing, but I can do this pro se. And that's why I filed a class action, by the way, to take care of this all at once. And
you hope down the road, and it's got to survive some motions to dismiss, but you hope down the road that other people can join in. And several people have asked me.
It's not.
They definitely want to join in. But answer this question: you say it's retaliatory. You're getting inside people's head. If they say no, we just weren't confident that Matt was ready to be a dad. He was just gotten out of. How do you show that it's retaliatory? How do you show that it's just to drag it out, as opposed to whatever reason they give? How do you show that it's like a criminal RICO conspiracy as opposed
They've never come up with any reason to withhold my children, ever. Still to this day, there's nothing in the record. The kid's mother came up with all this nonsense at trial. She said, first of all, at trial, that I kidnapped my children when I came back from rehab in 2019. I took them to Universal Studios. That's not kidnapping. And she admitted in her deposition at trial, or in her deposition at least, which I can post that it was on my days under the parenting plan. So I took them because I was gone at rehab for a month, and it was Christmas. We left Christmas Day, and we came back when my days were over. And she testified at trial and perjured herself and said that I took them out of school and that she was on the ground and the principal called her. And I just proved that lie. By the way, I filed a motion to ask Judge Hilton to refer all of her testimony to the St. Louis County prosecuting attorney for perjury. Of course, he's not going to grant that. But yeah, I mean, she perjured herself. All this case is full of perjury. I mean, John Fenley told me in the hallway during trial that people perjure themselves in family court. It's no big deal. It's outrageous. But back to, I practice law in a different world where perjury is a big deal. I believe that if you swear to tell the truth, you tell the truth. And if you don't, and you knowingly lie, that you're punished. That should not be accepted as normal protocol in practice. That's outrageous. And I still also believe that I'm doing this not only, if you read my pleadings, and I don't mean to make this, I'm doing this for I'm certainly biased. I'm doing this for my kids. The reality is I'm not going to get a resolution before my kids are 18 anyway. But I'm doing this for the other families and the other kids out there. But I'm also doing this for the profession. I'm personally offended that these criminals are allowed to wear black robes. I believe in the justice system. I really do. I'm a true believer in it. And what's happening here is embarrassment's not even the fair word. It is a travesty. No, I fear that if you live in Missouri and shouldn't trust or should have a reason to mistrust, at least in St. Louis County, what happens in that courthouse. And that's unfortunate. And that has to change. And that's what I think the federal court can step in and say, listen, the state's not doing anything about this because here's why it matters. Richard, to go back to your question, there's U.S. constitutional rights at issue here that aren't being enforced and protected by the state. That's when the federal court steps in and says, okay, there's also RICO violations, but I have a Civil Rights Act claim that we haven't talked about. But so the state is not protecting the civil rights of these people. So that's why I mentioned desegregation. But there's instances when the states don't behave and the states don't follow the law for various reasons, when the federal court has to step in, and they have the power. That's why they're the federal courts, to step in and make sure that the U.S. Constitution, those rights are enforced and protected. Not enforced, but those are the protections guaranteed by those by the Constitution are implemented in the states. And that's what I'm asking for in this case, and why I think it will proceed past the motion to dismiss.
And that Senator Fincham from Arizona, who we talked to, actually agrees with you in the sense that he sees the problem with the family courts as a civil rights issue. He's mentioned systemic extortion almost, that people are compelled to agree to different things. And so I think that you're on the right track there from a messaging point, just solely from that perspective. My question for you, though, is a big one, and I don't want you to be too forthcoming because I don't want you to give anything away, but in most, RICO is a hard case to prove. And in most successful RICO cases, from my experience and from the study of RICO and the history of RICO, you need somebody on the inside to flip. Do you feel that you need that for your case, and how close are you to something like that?
So I don't think I need someone to flip, but here's what I do think. And that's why I'm on this. And thank you for inviting me to be on this podcast. I think that if you look at one of the individuals on Facebook, there's 90-something thousand views on my filing. That's one of the 2 articles that are out there so far. There's multiple. But as this gains momentum, the U.S. Attorney's Office is going to have to explain, and the new Missouri Attorney General, there's going to have to be an explanation as to why no one has pursued this criminally.
I can tell you that a lot of the people who I was talking to in 2021 went to the local office of the FBI. I don't know if we're talking about the same person. I talked to several. The FBI is well aware. They know about that Zoom conference. They haven't done anything yet. You're right. You're hoping that you'll trigger them.
Well, maybe. First of all, I have a witness who has recordings of conversations with the FBI, by the way, that they can authenticate and introduce the legal recordings of Missouri, authenticate and introduce into evidence. But it's not going to be undisputed that I have another witness who's personally brought 25 people, a lawyer, brought 25 people to the FBI on the same issue. But the FBI is, again, they report to the U.S. Attorney's Office. So, and I want to make this clear, the U.S. Attorney is at a fork in the road. Either they have to explain why they haven't done something, or they have been doing something and they need to come down with indictments, because they can't say this is a state issue. This is not a state issue, and they've been on notice of it for so long. And I'm not going to predepose. I mean, I may have my instincts and beliefs, but I'm going to follow. The whole point is just to get to discovery. Past the motion dismiss phase gets me discovery to find out where the evidence leads. If I'm wrong, or if it goes somewhere else, I just want to follow the evidence. Here's what I put in the pleading where I think this is going to show.
If you get this to discovery, and Joel was at discovery when he died, which is, I don't think, a coincidence, but if you get to discovery, in my opinion, that is the worst nightmare for the Missouri family court mafia, as we call them. You can depose people, you can get documents, you can get a lot of things, and they have a lot to hide that they won't be able to hide.
Absolutely. I mean, so this is all about money. That's why RICO applies, right? This isn't, I have claims about my emotional stress, which is significant. But this is a RICO and then Civil Rights Act claims. I mean, this is, I'm sorry, I lost my train of thought there. I lost it.
Rich, you want to ask him a question? Get it back on
Where was I there, Michael?
I'm going to continue your question, Mike. Are you afraid that if you take this too far, Matt, that you're going to get offed by the family court mafia? Are you going to get paid by some of the same people that were on the other end of the suicide hotline, the Hillary Clinton suicide hotline?
I believe that to the extent I had legitimate concerns, and I'm sure that'll come out later, about my personal safety early on. Now it's well enough situation that I think I'm safe.
You're too high profile.
Yeah,
Joel did an article with me, did a few things, but he wasn't that public. I don't believe for 1 second that Joel killed himself. He's making 6 figures. He had 50-50 custody. He was happy. No one who talked to Joel thought he was unhappy. He was in a good place in his life. I don't know what happened to him. I don't buy the suicide at all. Hopefully one day I'll find out. You keep mentioning, explain the civil rights aspect of the case.
Yeah, no, I mean the civil you can sue anyone under acting under color of law
Mhm.
that violates your civil rights and obtain monetary and or injunctive relief, right? So again, I'm going to run across the immunity issue for the judges, but I've also named the guardian ad litem. Guardian ad litem doesn't
But the
not have the
guardian,
same.
let me interrupt you. The guardian ad litem in Missouri have almost as much immunity based on their completely bogus case law as
I
the
would
judges. Aren't you going to run into a similar problem with Fenley? I think is his
I,
name.
I would disagree that it's almost the same. I'd say it's quite limited.
Okay.
And it's quite, in fact, I have the Eighth Circuit case that I've already pled my complaint around. I'm ready to go to the Eighth Circuit on that issue because
Mhm.
what Mr. Fenley has done does not fall within his what's called qualified immunity, not judicial immunity. Totally different situation.
Right,
Uh,
and with you can't commit extortion and ask for qualified immunity. In the same way that if you're a cop and you arrest someone, it doesn't give you the right once they're in handcuffs to clock them in the face. That's assault, and you don't have immunity from that. So
exactly.
I know that it's very broad. Michaela's law, which was named for Michaela Haynes, was a proposed law that Evita put together that never became law that would eliminate the guardian ad litem's immunity. But yeah, if it's qualified, it's definitely less significant than judges. With judges, as you can see, even if you take bribes, some judges will say, "Well, so what? As long as the bribe led to an order, that order is immunity proof, basically."
Yeah.
Rich,
So
anything else you want to add?
Oh, I think this was pretty eye opening, and this is pretty amazing stuff. And I wish you the best of luck in this, man. I really do.
thanks. I just want one final comment. So because I'm doing this on my own, I could not name as defendants everyone that I wanted to and everyone that I could have, right? So I'm going to have to respond to the motions to dismiss filed by the lawyers hired by each of those defendants. And my complaint
The
does
good
not
news is you're doing this full time.
right. Right. Well, and I'm going to ask the court, to kind of schedule these things out and do some what's called omnibus briefing, which is combine some issues.
Mhm.
But in this complaint, this isn't the final complaint. There's a little hint. There's
Mhm.
more coming. This is the first iteration because there's more. There is a
And
duty.
before I forget, you've already faced retaliation. You said for filing it. They put some sort of directive. Your limit if you go to the court in St. Louis. What do you have to do if you go to the court in St. Louis?
So the day I appear in front of the Judge Hilton, the defendant in this case, he mentions that he knows about the case at the hearing, which obviously, trust me, they all, just like they knew when I filed the Court of Appeals case before they were served, they knew about it. I mean, everyone talks
Mhm.
in this community, particularly when you file a suit against a judge. But yeah, so the next day out of nowhere, this is amazing. So when you file a federal court case, you have two options. You can have somebody, everyone knows you can have a process server knock on someone's door and hand deliver them the paperwork, or you can use U.S. mail and mail a copy to their house and say, hey, I don't want to have to pay for a process server. I don't want to have to go all that trouble. Why don't you sign this piece of paper, waive service of summons, and you get extra time to respond. It's called Federal Rule of Civil Procedure 4. I did the latter. I used U.S.
We know all about that, Matt. We've been covering this with a guy named Jeremy Hales for the past few months.
Right. So
Okay.
you do
So
that. What happens?
I mailed to Commissioner Greaves, who I think it's maybe important down the road. It's not a judge, but is a commissioner. Anyway, I mailed her copy to her home address, which I redacted as a professional courtesy from any public filing. I mailed to her address, and then I beg everyone to please look at the order and how it's worded and my response to that order. They said that there was some sort of threatening, suspicious package. It was an envelope from Walmart. And I have a photograph. I thought to take a photograph, Michael and Richard. I was at the downtown St. Louis post office and I knew something was going to come up. So I just took a photograph, just like when I drop off child support checks, I take a photograph that I'm there. And that to prove, because I know that something's always going to be alleged later. So yeah, they claim it's a suspicious package that I delivered myself or had delivered to her house. And that they called the police, or there's all this nonsense. And then there's now an escort order that he cannot enter under. There's clear law that once I filed my motion.
Is Hilton the one who entered this?
Oh yeah, of course it is.
All right.
So now I can't go to. I have to check in with security. I'm not allowed to walk around the courthouse as a lawyer as I choose, and I have to be escorted from the door to where I'm going.
And this is based on their interpretation that the lawsuit that you mailed, certified mail. And look, I tried this.
It wasn't even certified. It was U.S. mail.
That works only with people who want to be cooperative. Unfortunately, if someone is trying to avoid service, like my ex-girlfriend, that's not going to work because they just won't ever sign for it. Then you said this yesterday: motion for sanctions filed, I think, by the Garden ad litem, Fenley.
This is the latest. Yeah. So Fenley, so I knew I was waiting. So I finally posted his recording. I've had his recording. I submitted it. I filed it with the state court. I filed it with the Supreme Court. I sent it to the Supreme Court on a thumb drive. I attached it and sent it to the OCDC, Ethics Committee. But I finally decided, because I got so much going on, honestly. And it's great. I'm getting great turnout response from people. Just too many. I can't respond to them all, or really anybody individually. But so I posted on my website and I let everybody know. I said, hey, here's the recording. You listen to this and you tell me this man is not attempting to extort me. And then now I get this motion for sanctions, which doesn't reference that, but says that I cannot have a GoFundMe, which I can't use a picture of my kids. I can't have a website, and that I can't use supposedly Facebook to indirectly get to my kids, because we haven't even talked about the gag order. My kids are clueless of what is going on. They're 14 and 16.
You said the Garden ad litem is lying to them. Am I right?
He absolutely is lying to them. He has told them time and time again, this is all about when we're going to 50-50. He's lied to me and told me that. Now the jig is up, because this is how they drag it out. This is, don't worry, we're going to go back to 50-50. And that's why the kids don't have a mutiny.
I wanted to get this article up. Your article basically is going to try to prove the point I made in 2021, that St. Louis County courts are a criminal enterprise. And I made 2 points in this. It's a lot easier to prove it if there's bribery, which there's not. However, I said, if you can show one crime clearly, like you're going to show with the attempted extortion, it's easier to believe everything else leads to the same criminal enterprise. I was arguing in the theoretical. You're about to argue in court, in reality, with real facts. And I was using, like many cases, and a lot of hypothetical arguments. But it's interesting. You are going to either prove or disprove the theoretical argument I made about 4.5 years ago.
I want to recognize those that did this before me. I put it on my Facebook. I stand on I saw this somewhere else. I can't claim credit. I stand on the shoulders of those who came before me, and I don't mean to make light of that comment, because I do mean it, which is I'm just the latest victim, but I happen to be a lawyer and happen to be one that worked at one of the 100 largest firms in the country and was one of the, not only a partner, a equity partner in the litigation group. I know what I'm doing. I'm very humble about my qualifications typically, but I know what I'm doing. And I can't believe they decided to do this to me, because I'm the one, I know how to defend myself. And when I'm defending myself, I'm going to defend all of the children and all of the families in the future, because this has to end. And that's what this is about. That's my mission, is to end this.
Right. In the other case that Hilton was in, they forced Caroline, the mother, into 50-50, and that girl lives 50% with the guy. And there's a notorious recording with Elaine saying, did he stick his finger up her butt, meaning Mel and his daughter? I don't know. I wasn't there. This is how they hide it. They're forcing that girl to live 50% of the time with her abuser. There's a lot of cases like that. Angela Feiner's another one where they sent the girl to her abuser. There's many. Ken Rosa was forced to not spend any time with some of his kids. Other kids, he's a perfectly fit dad. There's a lot of cases you can draw from. But Rich, any other questions or any other thoughts you had?
This is awesome. Thank you.
If I could, Michael, ask a courtesy favor. One thing, the most important thing about the motion for sanction is they're taking issue with me filing on the internet the pleadings in the case that are redacted, because they don't want. This is the whole point. The lack of transparency is how this works. They don't want anyone to see.
I'll make you a promise as a member of the press. You send them to us, and we'll publish them.
Yeah, they're all on my website.
Their argument's going to be that because yours is what they call a paternity case, because you weren't married, that it's not supposed to be released. It's bogus. You're
the redacted
right.
Versions can be.
The lack of transparency is how they get away with this. I wasn't allowed into Angela's court hearing because it's a paternity case, one of the worst cases in that court. Anything else you guys wanted to add?
No, we've run long, and sorry. Thanks for and thanks for inviting me. Like I said, thanks for anyone to get the word out. And like I said, there's an intake group. If you check my Facebook or the group on Facebook group, we have an intake we're organizing all these witnesses, and because this is going to go through. I can't make guarantees, but I've done everything I can do to make sure this survives motion to dismiss. and the discovery is going to destroy and prove everything.
If you get to discovery, that is their worst nightmare, and you're probably going to get very, very far. I think you can prove a lot of things once you can get